Hi, everyone. We're moving on with Chapter 12. So last week we went over all of the steps in the process. Then we went over all of the actual steps of pretrial motions and what motions to make. And we even talked about the final project. So hopefully everybody's starting to work on their final project. This week, we're still staying with Chapter 12. So we're going to cover Chapter 12 for 2 weeks. This week, we're going to take a closer look at the actual players in the system and what each of them do and what their duties and responsibilities are. Okay, so just to get us thinking about it, who are the players in the criminal justice system? So who are we going to be talking about? Well, the judge, the prosecutor, and defense attorney are the key players in the criminal justice system. We are going to just focus mostly on the prosecutor and the defense attorney and the procedures that govern them. Okay, so just to quickly review, let's talk about some of or what each of their kind of general responsibilities are and talk about a few other people that work in the system. So this person is responsible for presenting evidence at trial to prove beyond a reasonable doubt that the defendant committed the crime. So who has the burden of proof to convince the jury at trial that the person committed a crime? This would be your prosecutor. So we'll get into more details about the prosecutor in a minute. This person rules on evidentiary issues and determines if the evidence will be permitted in the court. This person also rules on court objections. So this is the neutral referee that controls the trial. This is your judge. Okay. Now, this person keeps the court calendar and schedule for the judge. This is your court clerk. Your court clerk is sort of the chief administrator for the court, keeps the schedules, keeps track of the evidence, is sort of like the master organizer for the judge and makes sure all of the cases are brought in an orderly manner and people know when they have to show up. This person maintains order in the court. This is your court officer or your bailiff. Those terms are often used interchangeably. They're usually police officers or they're state police officers that work specifically for the court officers. This person is responsible to make sure that the government meets its burden to prove guilty beyond a reasonable doubt and also make sure that their client's constitutional rights are protected. So this person represents the accused. So this would be your defense attorney, okay? And then this person is responsible for typing up everything that was said in court. This is your stenographer or court reporter, okay? So those are some of the main players in the system. So I had a little practice quiz that you can take if you want to review any of their jobs. Now, we're going to spend the next 2 lectures specifically looking at the different attorneys and what their roles and responsibilities are in the system. So first thing is, what do you know about becoming an attorney? So just a little knowledge, general knowledge about being an attorney. What schooling does a lawyer need? Just a high school degree, a college degree, or a law degree? Well, what about this one? What is the test that students have to pass to get into law school? I don't know why I thought it changed colors. So the first one, what school do they need? They need a law degree. So what tests do they have to take to get into law school? That is the LSAT. So you have to take a special test to get admitted into law school. What tests do you have to take and pass to become an actual lawyer after you've completed all your school? That's going to be the bar exam. And who does the defense lawyer work for? The accused. Who does the prosecutor work for? The state. And what is the prosecutor's job at trial? To help the government get a conviction. And finally, what is the defense lawyer's job at trial? To protect their client's rights. Okay, so that's just some general knowledge. Oh, I have one more. What should the defense lawyer explain to clients about the case? everything, all of the above. So one of the things you'll see in here when we talk about defense attorneys in the next lecture is they are the voice and teacher to the defendant, because the defendant may not know what's going on. So the defense lawyer has to explain everything to their client. Okay. Now, it's important to remember we have what's called an adversarial system. This means that we have two sides to the case. So we already said we have prosecution, we have defense. The idea is if the two both duke it out in court, not physically, but intellectually with evidence, and we both have people advocating or arguing strenuously in court for their side, then the truth will rise to the top and the jury or the judge will be able to make a determination about guilt or not guilty. So the idea is if they both work as hard as they can to present their facts, then the truth will ultimately rise to the top. Now, a lot of times we come up with this issue, especially with prosecutors, what should be the most important part of our system? Should it be that the attorneys only care about victory and they only want to win? Or should we be really worrying about reaching the truth? Because remember, we're criminal justice. So what's really justice? The person fighting to death just to win, or the actual truth? So that's often a debate that comes up in the discussion of the criminal justice system. So we are going to start today specifically looking at the prosecutors and what the prosecutors do. And so there's this quote, the most powerful peacetime forces known in our country. I want you to remember that because we're going to talk about why they are so powerful in a minute. Now, when you're talking about a prosecutor, sometimes, so we're calling them a prosecuting attorney. Sometimes they're called the district attorney or the state attorney. Different states use different terminology, okay? So we're going to say prosecuting attorney. Their official duty is to convict the guilty while making sure the innocent are not prosecuted. So their number one duty is to seek justice. Is to seek justice. I should have had this come up first, okay? So they need to worry not only about convicting people that they believe are guilty, but if they have evidence or have any belief that the person did not commit the person, they can't just want to win. They need to do what's right. And they also have to assure that no innocent people are ever prosecuted and put into jail. Now, just as an aside, prosecuting attorneys mostly are elected, okay? So, and they usually serve a 4-year term. So it's an elected position. A lot of times they also act as a quasi-legal advisor to the police. So they would help the police in making decisions about warrants and probable cause and all of those legal concepts we've talked about. And don't forget, they're the ones that carry the burden presenting the evidence at trial that the person did in fact commit the crime beyond a reasonable doubt. Okay, but doing all of those things, they always have to worry about seeking justice. They always want justice, not winning, justice. Now, prosecutorial discretion. We talked a lot about discretion with policing. What is prosecutorial discretion? Well, prosecutorial discretion is the ability to make choices within the criminal justice system. So what discretionary choices do they have? Do they get to make? Well, they really make almost all the decisions. That's why they are known as such a strong peacetime force. They have tremendous power. Police get to arrest and present the evidence to them, but they ultimately have the decision of what the charges will be. What's the level of crime that that person will be charged with? They also are the ones that control plea bargaining and sentencing recommendations. They can choose not to charge the person, what evidence to present. So they have a ton of discretion. So some of their decisions are these charging decisions. So they have to look at what the police bring them, and then they have to decide, are they going to charge? So number one, do they want to charge at all? Then they can decide, maybe they don't want to charge. Maybe they decide to divert the case to somebody else. So we have drug courts we talked about, and we have different levels of courts. You could divert a case to counseling, rehab, another court. So that's diversion. That's saying we're not going to charge you in this criminal system. We're going to send you to somewhere else instead of criminal consequences. They could decide to release you completely and say, no, we don't think there's enough evidence. We're not going to go forward. Or they can decide on plea bargaining. Are they going to offer lesser charges? And what is the possible sentence they're going to recommend? So they have tremendous power in charging. So just to give some examples to get you thinking about it, Frank is charged with criminal sale of possession of cocaine, but has advanced stage AIDS and other illnesses. His doctor believes that he only has 4 months to live. So you're the prosecutor, you're very busy, you have lots of work. Are you going to charge this person with the crime? Or are you going to divert him, or are you going to let him go? So that would have to be your choice. And what about this one? A student stole a textbook from a library. He works part-time to pay for school. He could have paid for it. He just would have been really difficult in his budget. He had never, ever been in charge with the law before. What are you going to do? Are you going to charge? Are you going to divert? Are you going to let him go? The last one, a 50-year-old slips a pair of earphones into her purse. She is wealthy and adamantly denies that she did not intend to steal the earphones. She says she put them in her bag so she could pick up some film and batteries and other small things, and simply forgot that she put them there. What do? Do you charge or don't you charge? So that's to get you thinking. Remember, it's the prosecutor who has this choice. The prosecutor has the ultimate choice on whether to prosecute. The police may be mad if they don't, but they can't do anything about it. It's the prosecutor that has the ultimate decision. But remember, they are elected, so they do have some outside pressure to do certain things because if they want to be reelected. Now, another thing they have a lot of control over is this Brady material that we talked about, or pretrial discovery. Remember, the Supreme Court says that the prosecutor has to turn over anything that the defense asks for that's inculpatory or exculpatory. But remember, it's all in the control of the prosecutor. So the prosecutor has to make ethical decisions on what to turn over and what not to turn over. Some prosecutors, in order to avoid any difficulty with Brady, have an open file policy. If your defendant is charged and you want anything, you can come and they'll hand you the whole file and you can look through it. So there will be nothing hidden or secret that they were supposed to disclose. But that becomes a huge burden and consequence to prosecuting attorneys. The next thing they get to do is they get to decide what evidence they're actually going to use at trial. As long as it was legally obtained and not excluded from court, the prosecutor can decide if it's useful or not useful to use at trial. The prosecutor may also develop the theme of this person or this case, right? So the theme is going to be how you're going to explain it to the court, to the jury, to get them interested in the case and want to hear about the case and kind of frame the defendant in a certain light. And the prosecutor would choose that theme. Now, because they have so much discretionary power, prosecutors can abuse this discretion, and they can violate ethical rules by abusing their discretion. How can they do that? They can use personal considerations in their decision-making process. So they really don't like somebody, they could choose to prosecute them. If it's a family member, they could choose not to. They could use it as a way to harass somebody. They could overzealously prosecute. That means charging too much, too hard without looking for what's really justice. Remember, prosecutor's sole duty is justice. They could do selective prosecution, which would somewhat a lot of times be discriminatory prosecution. So you only charge Black people or women or Hispanics. That's selective prosecution. You could have vindictive prosecution. So somebody is found not guilty and you're really mad. So then you just go after them and prosecute them for something else. So they can violate their discretion. A lot of times they can get sucked into what we call noble cause corruption, which we have talked about with policing. The idea that, okay, it may be okay to violate some ethical rules and my duty to seek justice as long as it's for the greater good. I really know this person's bad and I really want him to be put in jail. So even though it may not be ethical, maybe I'll hide some of the debrading material, or I'll do other bad things in order to convict the person because I think that's the best result. And people can get sucked down that road pretty easily because you start to feel like you're the only defender of society. But you have to only use what's ethical and legal, because you always have to keep in mind your duty is justice. It's not to seek a conviction. So in recent years, one of the things that's been proposed is, in order to have the system be a little more fair, all prosecutors should have to serve as a defense attorney for at least 6 months out of a 3-year period, so they can really see the other side. If they're truly seeking justice and want the process to be fair, maybe they should work as a defense attorney for a while and see it from that perspective. It's kind of a controversial idea. There's arguments out there for it and against it. I think it would be logistically really hard to ever do this, but I just think it's super interesting to think about as a possibility. I don't know if it would ever work, but it is kind of interesting. Now, what is the punishment if prosecutors violate their discretion? They can be admonished by the Bar Association. Remember, they're elected officials. So if you're the district attorney, your boss is the public. If you're an assistant district attorney, your boss is the district attorney. So you could be admonished by your boss or by the public. You could have public reprimand from the Bar Association because you have to be a lawyer. You could be suspended from the practice of law. They could revoke your law license, and then they could permanently disbar you. You could never, ever be have a law degree again. You could never be an attorney again. In reality, prosecutors are very rarely punished in any way. The idea is that, well, if they do something wrong, they just won't be reelected. In reality, most people don't even really know what the prosecutor's doing and can't really hold them that accountable. So it's very hard to hold prosecutors responsible. Now, the question is, what if you find out the prosecutor prosecuted you wrongly, knowing that it wasn't just to do? And there's really nothing that the defendant can do. You cannot sue a prosecutor. A prosecutor has what's called absolute immunity. Police officers have qualified immunity. You can sue police officers as long as it's outside the scope of their employment and they went beyond what they should have done. Prosecutors have absolute immunity. You can never, ever sue a prosecutor for anything they did in their duties. Okay, so that's the end of this lecture. So now you need to start thinking about your Chapter 12 assignment. So it's a little complicated, so I'm going to spend just a few minutes talking about it. So when you go to the assignment, you will see that there will be 5 case reports. They're just 1 page, they're not very long. So you need to read through each of those 5 case reports. On those case reports, you'll see at the bottom, there'll be a list of possible charges that you could charge each person for, okay? So what you need to do is you need to go through, and there's a chart you're going to fill out for this whole thing, and I'll show you in a minute. You need to decide first, when you first read through all 5, you need to decide what are your preferred charge. In a perfect world, if you could do anything you want, when you read those scenarios, which crime would you want to charge? What would be your preferred crime? So I just want to show you, hold on one sec. I just want to show you what you'll be looking at when you're doing that assignment. So I should have opened it ahead of time. I'm sorry. So let me find it real quick. Get closer right here. Okay. So this is your You Be the Prosecutor assignment. So you will see when you read through, it gives you very detailed directions. So the first thing you're going to do is you're going to read your 5 cases that are posted under the material. And these are the name of the 5 cases. So the first time you read it, you're just going to tell me out of the list, which one of those crimes would you ultimately pick? Okay. Now, after you fill out the preferred charge, you need to look at how many units you're expending for each charge. So if your preferred charge is a D felony, you're going to write in here what the crime is, D felony, and then you're going to write 5 units. So you're going to give yourself the units based on the level of crime that you ultimately chose. So that's the first step. Your very first step is to read through them and give your preferred charges and list your units that it would be for each one of those charges. No restrictions. Once you do the first column, now you have to go back. And what is happening is for the second part now, I am going to restrict you to only 14 units. So when you recount all of your units up, I would guess you're most likely going to be over 14. So now you have to figure out what reduced charges could you give to get you down to 14 units. This is supposed to represent the hours in the day and the resources that are available to you. As a prosecutor, you cannot charge every case to its maximum. You do not have enough time in your day. You do not have enough financial resources to do that. So you have to pick and choose your charges and your cases you're actually going to take to trial. So if you decide to take something to trial, and it's a high crime, it's going to cost you more units, which is more time and resources. So in order to show you how it is in reality, I'm only going to give you 14 units. And so you're going to have to narrow your charges down and figure out which ones you're willing to charge less or plea bargain. So there's one in there that's starred. That's the plea bargain. If you agree to plea bargain, that one is only going to be worth 1 point. Okay. So anytime you plea bargain, it's only going to cost you 1 point, but you have to pick the one that's starred. Okay. And then here, I just want you to give an explanation of how you made your choices to narrow down to the ones you did. So when you add up this middle column, you cannot go over 14 units. Okay. And then after you do all of this, I want you to just answer these few questions. Were you satisfied with the final results? Why or why not? What do you wish you could charge if you could? Like, why is this difficult? Why did you make your overall choices? Do you like the plea bargaining process and your overall reflection on doing this assignment? Okay, it may be frustrating, but that's kind of what it's supposed to create. So make sure you go through it. If you have any questions, reach out and I'll be happy to go through it with you. Okay, so hopefully that gives enough explanation so you'll be able to complete that assignment. So I didn't give you a word for this lecture, so we'll make the word for this lecture plea bargain. Okay, so I will see you to talk about defense attorneys in the next lecture.